Okay. And post-entry is another reason. I talked about this extensively. Representation after entry summary acceptance. Any time you clear the entry, you have to submit. We talked about it last time. You have to submit documentation. That documentation usually includes entry summary. It doesn't have to. It can be entry, like 3461, and entry summary has to be followed up usually within 10 business days or calendar days. You have to check on that. But usually once you file the entry summary with duties, anything that's done afterward, let's say you want to change the entry summary, okay? This is post-entry work, okay? And usually post-entry work is being outsourced because it's sort of a different animal. It's no longer transactional work per se, but it is more, it involves more research, because if you want to change something, it is more than just administration. It becomes, it becomes more burdensome. So let's say you want some money back, or you want to change the tariff. Now you have a higher burden to tell the reasons and the basis of that change, and that involves more analytical aspects. And this usually takes not a transactional type of people, but more an analytical type of people. And within corporations, you see those. Usually they break them up. The experience shows that usually this type of people should be separated from those, because transactional people, they want to make sure that everything is done timely, and analytical people want to make sure everything is done thoroughly, and sometimes there is a conflict. And for this type of situation, representation after entry summary, if you have a team of people that are located in one place, let's say Portland, Oregon, you have folks who do all post-entry, okay? Then this type of national permit is helpful. Let's see. Oh, there it is. Okay, remember that. Penalty amount for transaction conducted without a permit is $1,000 per transaction. Okay, so if you don't have a district permit, a national permit, if you have an employee implant without a national permit, every transaction, and what that transaction is also a difficult question, because sometimes they may be related. So to go around this difficulty, Customs made this contemporaneous exception rule, which is in italics, okay? It says separate penalty should not be assessed for each transaction if numerous transactions occur contemporaneously. So you're doing the block entry filing, okay? Or you're advising on classification if you're an employee implant on the batch of products which are going out at the same time. That means it can qualify for contemporaneous exception, so you pay $1,000. Important number to remember. Okay, we're still on definitions. We are talking about employees, okay? Employee, who is an employee? Employee, well, is a person who serves as a licensed customs broker, okay? So we mentioned that if you're an employee, license is not required. Well, look at this. An employee is actually limited to what it can do. Employee may perform the functions of a broker if a power of attorney has been issued and a statement identifying the employee so authorized is filed with the director of each port, okay? Of each port where the business is transacted. I believe the national permit, there is a national permit exception, so this rule applies to the district port permits, okay? But what we will come back to that later. What it also mentions is there is a filing requirement. So there is as an employee, you are doing it on behalf of an employer, but at the same time, you also are doing the work which can be regarded more like independent contractor work. Why would that be the case? Because, as we shall see further, you are required to file this billing statement unless there is a waiver for each brokerage service performed. And this billing statement requirement can, if you are getting paid by an hour, why do you need to go through this? Okay, this will be like, I get my certain X amount of dollars per hour. Why do I need to provide the billing statement? It's only if I am an independent contractor, right? So let's say I made a contract, I bill you for services, and in addition you pay me hourly salary or a wage. It doesn't make any sense. So there is that conflict that I want you to keep in mind for now, because regulations are not doing a good job of making it clear. Okay, and why am I making a pause on this is because if it's not clear, you may not, it is helpful to just remember this, okay, without trying to actually make sense out of it, because if you try to make sense, you have the 1099 versus W2 conflict, okay, what can you do? So this is one of those things that is better to remember rather than to try to understand it from an analytical perspective. You can, but it will take you time. So, an employee may perform the functions of a broker if a power of attorney has been issued. To whom? To the employee. And a statement identifying the employee is filed with the port director. Please just remember that. Okay, next. Freight forwarder. Okay. Well, also known as 3PL, third-party logistics provider, takes stuff and moves it on your behalf, okay, on behalf of other persons, the key provision. Corporate officer, in compliance with corporate formalities, okay, makes sense. I think I mentioned already that they must, if you want to, as a corporation, if you want to transact customs business, those corporate formalities must mention that the corporation is allowed to engage that. Otherwise, it will be what's also known as ultra vires, okay, which is you can only do what a corporation allows you, and if you don't do what corporation allows you, you're not really authorized to do that. If you're not authorized to do that, then you cannot engage as a matter of corporate law in a customs business. So corporate formalities is an important part. And representation before government agencies. So this part deals with the topic which we keep coming back of the Department of the Customs and Border Protection is under the Department of Homeland Security. Okay, the agencies are usually under departments. So what this means is that if you are within under Department of Homeland Security, right, you can represent the client before the Department of Homeland Security or any representative, meaning any agency of DHS. So if it's ICE, usually ICE is a different department. I think it's under DHS. Okay, it could be under Department of Justice, but ICE usually does investigations. They do the enforcement portion. So ICE is Immigration Customs Enforcement. Okay, so if they suspect you smuggle drugs, it will not be the Customs and Border Protection. Well, it will probably be ICE. Okay, can you represent ICE as a licensed customs broker or communications? Even though it's different agencies, yes, you can by this rule. What about not within Department of Homeland Security? So Food and Drug Administration is considered to be under the Department of Health and Human Services. Department of Health and Human Services, DHHS. So you have Fish and Wildlife. Fish and Wildlife is under the Department of Interior. Okay, so as a licensed customs broker, you're often involved. The customs enforces all these other laws. Okay, so you must get a permit from the Fish and Wildlife if you want to import, let's say, shells. Okay, see, you know those shells that you can see in Dollar Tree store, like they usually come from Philippines, okay? Those require the permit from Fish and Wildlife Services. And to get those permit, you have to deal with the Department of Interior, which is not within the Department of Homeland Security, okay? And therefore, you must comply with any regulations of that agency, okay? So to appear on behalf of your client, you come into the Department of Fish and Wildlife Services and you represent your client. You get stamps, you get all the permits. How can you do that, okay? If there is other issues, for the DHS you have to have a power of attorney. If there are additional requirements by the Department of Interior, you have to check. Then you must comply with those additional requirements. That's pretty much what this rule says. Any questions? Okay, this is big, okay? Responsible supervision and control. Very broadly written and covered. Look, it's covered in 111.1, 111.19, 111.28, okay? Customs broker must make sure that its employees, unlicensed employees or even licensed employees which do not use their license, they provide substantially the same quality of service in handling customs transactions that the licensed customs broker is required to provide. Okay, very broad. What is substantially the same quality of service? Of course, it's on case-by-case basis. So if you have a large company with many employees, how you make sure that it's the same quality of service? What if you hire temps, okay, all the time? So we have a season like DHL or UPS. They have a seasonal shift, right? So they hire a bunch of temps to clear customs entries during the peak season from September through December, okay, which is normally the peak season for the industry and the freight forwarding. Okay, they hire a bunch of temps. What is their background? What is their education? What are they doing? What they have been doing? How are they supervised? Okay, the scrutiny for the temps will probably be more than for persons who has been employed for the same company for more than 10 years and knows what it's doing, knows how to fill out the paperwork, although it doesn't have a license or is conducting business under someone else's license as an employee. Okay, so responsible supervision and control is a term of art. It's a relative term. So what customs has done is it came out with a list of factors, okay, and those factors again is an evaluation criteria which, depending on the size of a company, resources, and the way it conducts business, are evaluated on. And you may be asked on those factors because they are listed in the regulation, and the way you will be tested is they can just throw a bunch of the factors and they'll say circle or choose the factor, choose the point which is not a factor, okay, in responsible supervision and control. So this way it is helpful to be aware of what these factors are, and of course first is employee training. All right, if you have a good training procedures in place, whatever they may be, it's a factor. Written instructions and guidelines. Okay, so you have a SOP, Standard Operating Procedures Manual, and it's being followed. Not just that it's dusted on the shelf, it's a factor. Volume and type. If you have a small broker, let's say a small family-owned customs broker, which is a rare sight these days unless you're a specialty, you don't have resources to train. Okay, so it can be a factor. So you cannot provide training on the same basis as a large corporation. Okay, so it's a mitigating factor. The rejection rate. Okay, you got rejection. What have you done to fix it? Do you get rejections for the same type of occurrence? Again, are you? It ties back to the instructions and guidelines and training. if you have recurrent rejections, it's a problem and you can get penalized. This is becoming new, but it used to be back in the day when most of the customs brokers, they use electronic HTSUS, and you all have links. Hopefully you all looked at it. But if you are doing customs entry, you usually have two screens, right? And one screen is HTSUS, another thing is and Code of Federal Regulations. Another screen is you have AS400, let's say, it's IBM program which communicates through ABI, or now you have a verb-driven programs such as ACE, Automated Commercial Environment. There is cloud ABI programs which communicate with customs. So you have screen with regulations which is up to date and current. So this become less a problem. It used to be that I remember I used to work for one customs broker. Part of my job was whenever customs comes out with an update, I have to get a copy. Okay, I have to get a current copy to make sure we comply with that responsible supervision and control requirement. Availability of licensed customs broker to consult non-licensed employees. So sometimes you do not have a licensed customs broker on site. Let's say you have permits in Boston and New York, and but you only one licensed customs broker. Okay, sometimes you cannot be at two places at the same time. That can be a factor. If you are there sometimes, how often? Okay, so and then again, frequency of supervisory visits, again mostly to the corporate entities, to the incorporations, and audits, also a substantial thing, requires a lot of resources. Not everyone can afford it, but if you are a large corporation and you have a person who may even be doing check audits, which is done in the form of check sheet. Check. Have you done this? Have you done that? Have you done that? Have you done that? And you must sign your name. If you implement that procedure, that can qualify as an audit too. So this type of stuff are the mitigating factors which go into the evaluation of responsible supervision and control. Let's see. Qualifies for the district permit involved. Okay, this goes to the naked licensing. So where you hire a person, but he's a retired person in Florida, but you use his license for the operation. You cannot do that. Okay, he must do some oversight if his license is used. Circumstances indicating that individually licensed broker has a real interest in operations of a broker. So, is he a shareholder? Is he a member? Does he have a stake in the outcome? Those are the points which are evaluated by customs when they assess this responsible supervision and control requirement. So this is very broad, okay? This is very broad, and many things can cover this, but if you see those factors listed and you see something that stands out, which is not, then it will be usually done, ask which one is false. And if you've gone through this enough times, what I will ask you to do is, once you get home, next Monday, or actually tomorrow, up to the next Saturday, go through this outline every day. Read through it, and by Saturday you will recognize a set of factors, so it should be a breeze for you. Okay? By that time we'll be ready to move to the next topic, which should be record keeping and powers of attorney. All right. So district permit applicant. Okay, here is another rule. Okay. So district permit applicant must employ in each district for which a permit is granted at least one individual broker to exercise responsible supervision and control. Okay, this is a general rule. So let's say I have a district. I run my own business in New York, and I run my own business in Boston. All right. I must have, and the general rule, I must have employ a licensed person in Boston if I am in New York myself. all right? But of course, as you will see throughout, to each general rule there is an exception, and exception entails the waiver, which I can ask customs to grant by saying to customs, look, I am a customs broker. I'm a small business person, and in larger geographic area, I am constantly overseeing this. I am constantly moving between New York and Boston, okay? And I have procedures which are adequate, such as employee manual. I show up there every other day. I monitor the email communication. I keep in touch with the clients. I conduct training activities, and we have meetings once or twice a week with the Boston office. These procedures are adequate, and I request a waiver to not employ a licensed person, okay, within the District of Boston, because my own presence is sufficient. It's adequate, okay. If customs grants a waiver, it is possible for me to get away without employing licensed individual on site in Boston. All right. Now, if you apply for customs brokerage, you will be required to submit certain information, which in turn your employer will be required to submit to customs, and this is by regulation. Okay. So regulation says every employer must submit information about you, the employee, to the port director at each port where the broker intends to transact customs business in writing, and upon issuance of a permit for an additional district port, or upon opening office at the port within the district. So every time you open a district permit in another port, so I operate in New York, I opened up in Boston, I also have to notify the Boston, okay? Opening of office at the port within the district for which the broker already has a permit. So I open up another office. I have two offices in the same district port. I also have to notify, okay? So this notification about employees is a requirement, okay? But there are exceptions. I mean, there are certain points which may not necessarily be required. But let's take a look at the type of information that must be submitted about you if you're an employee, or if you're an employer, which you have to submit about your prospective employees to Customs Port Director. Okay, Social Security number is the one. So whenever you keep in mind, this is before. So before you can even make a single transaction, if you're starting up a new business operation, you have to submit to Port Director information about your employee, each employee, okay? And why is that? Because sometimes Port Director can say no. Sometimes Port Director must say no. In which situations the Port Director must say no? They say, no, this employee, you cannot have this employee. It pertains to persons who have demonstrated that they're dishonest or disreputable, such as they have been convicted of fraud while being customs broker, had their own license taken away, but they want to stay in the business, so they come to you and ask permission to work for you as an employee. Okay? This is since the license will be given to you, that license entails a presumption of honesty. Okay? You will get, you're in position of trust, because you are deemed to be a professional, and if you're going to employ a person who is not entitled to that position of trust, that may be a problem. So this type of situation where you have to advise each port director where you're going to have an employee, is a system of checks which is used to prevent this type of situation. So, social security number, date and place of birth, current home address, I'm on top of page 16, and 3-year employment history. Okay, so if you're going to hire as an employer someone, you're probably likely to ask on application, where have you been employed for the last 3 years? All right. What if there is no employment history? What if you're just newly out? You haven't worked. You're just freshly out of college. You just say there is no employment. I haven't been employed for the last 3 years. Right? I think that's reasonable. Okay. So, but do you have to do that right away? And the answer is no. Okay? Because when a licensed customs broker hires a new employee, the broker must submit that information within 10 calendar days after the new employee has been employed for the broker for 30 consecutive days. Remember at the beginning of class I mentioned the dichotomy between consecutive and calendar? Okay? And I used the example of where you are deemed to be employee for 30 consecutive days even though you take weekends off. If they would use the phrase calendar, then you actually work 5 days out of the 7. But what about the weekends? So to make up for it, they did this consecutive day employment. All right, it's not like you're getting fired on the weekend and coming back. So you work for 30 days for a month. Okay, about a month, 30 days, and that 30 days is kind of like a regulatory trial period where if you're an employee, the employer customs broker looks at you, see if you're fit. If you are the employer, it's again you have to see what that employee is made of, whether he's fit for the environment. Okay, and then after a month you have to notify customs port director in writing. All right, and then I have example of Barack Obama and Hillary Clinton, where never mind the names, but the customs will give you hypotheticals where they tell you the days, okay, and what they're really testing you here. Notice, Barack Obama hired Hillary Clinton as a new employee on June 1st. Through Hillary continued through June 30th, okay, so that's 30 days, okay, 30 including counting June 1st, okay. Obama has until July 10th, provided that there are 30 the calendar days to notify customs port director, okay. And what they do is they'll give you a bunch of answers. And is it July 10th, is it July 1st, or is it June 30th, things like that, so you can figure it out, okay. What we're really being tested on here, notice nothing mentioned, okay, about the days or filing requirement, except notify customs port director. This is the key word that if question is presented you're looking for, so you know that you're being tested on the 10 calendar day window after 30 consecutive days of employment in writing. Okay, what about people who get fired? Terminated employees. So let's say you work for more than 30 days, okay, you notified, let's say you have to send a notice within 10 days. So after 30 days of work, you send a notice on the 10th day that you had an employee. And then on 15th day, 5 days after you send notice, you fire that employee because that employee showed up drunk, drunk, intoxicated to work. Okay. Now, how soon do you have to notify customs that you fired that employee? Okay, because you hire a person, you notify customs. You fire a person, you notify customs. Okay, and the time frame is within 30 days. You must send a letter to customs or a fax stating that that employee has been discharged or is no longer with your company or business entity. However, if it's a corporation and you have a business officer of the corporation, he is a license holder, and that company is entitled to a license because of that officer. Remember, if a corporate entity can hold a license because of that business holder, then you have to notify immediately. Yes, you have to notify immediately because what's the relevance? What's the relevance? What's wrong with immediate notice requirement? Or what's the big deal? Well, remember, as we shall see, and as we started this class with, that there is this 120-day window period where the company, unlike any other entity, can function, can transact customs business without a license. Okay, so this provides notice to customs that 120-day period has started. Okay, and so it can do whatever it has to do on its own end to make sure that you, within sufficient time, within 120 days, obtain another officer who has a license. Okay, so that personal license can have a great impact on an individual as well as on a business entity. That's why it's a valuable thing. And you see a lot companies, they are in their situations trying to find a person for that particular office because they say, okay, we don't even care about your experience, just tell me you have a license, we'll take you in, because that's all we care for, otherwise we have to shut down the operation. Okay, so, and this type of desperations I've seen happening in some of the offices of North Carolina. I won't name the company, but it does happen. It does happen. Okay. What if I lie? Remember, the false statement of material fact it carries a penalty. Okay. What if the employer hire lies to me? What if, in fact, that person is convicted felon? If dishonest person, what if they've been smuggling drugs from Mexico to the United States? Well, the licensed customs broker is not responsible so long as he doesn't have knowledge. Okay?
Question. So would the customs background check the employee? Will they do it?
Customs will check. I'm not certain what type of database they have. I know that they have specialized agents, special agent in charge within customs, kind of like almost like FBI, and they are specializing in looking at the various backgrounds. Okay, I think they have less scrutiny than if you are applying for license, because to get a license, you have to apply for. You have to go through the background check. You have to submit the fingerprints. Okay, fingerprints is usually one key biometric database which is tested, which is checked, and which is relied on in these countries' investigative agencies. Okay, usually state agencies submit that information to FBI, and then FBI maintains a central database of this. So whatever transpired usually sits somewhere in the FBI archives, and this is what they rely on most of the time. Whether there is any other source, they do not announce it to public. I hear that there have been some kind of there was this company called Sysint, and with Sysint back in the mid 2000s, they collected a large amount of database on individuals, and they would have sell this to agencies such as FBI and law enforcement agencies. Sysint was later bought by, again, I think, by LexisNexis, which is the Arkansas-based company, which collects information on individual. I, as an attorney, have been using LexisNexis because we have they have the person search, and sometimes you have to serve notice, right? How do you find that person? Well, within the New York State, to give a notice, you have to have a last known name and address. Okay, how do I meet that last known name and address from? I go to LexisNexis and I type in, and usually I have everything from Social Security to the list of addresses, so it's pretty powerful tool. It's private though. This is private, so whether they do that, I do not know. But nowadays, with everything digitized, it is possible to have to have checks. And plus, if there is if you've been convicted of a crime, it's a public information, and within the federal court system, I think PACER, that's the name of it. It's a system where you can check pretty much any person who acts as a defendant in this particular case or not. So Bloomberg Law just 2 years ago they rolled out something called e-dockets. So even you have not been convicted, if there is a case against you, your name will show up on e-docket. So which is another tool. So nowadays it's becoming more and more easier to do this. So just your name may be enough. That's what I think. All right. Let's see. Do you guys want to take lunch?
Yes.
Yeah, let's take lunch. So let's see. So we shall continue. I told you that it will be flow over. Okay. In the future, I will be going more quickly through the rest of the stuff, because a lot of this, at the very beginning, they covered a lot of substantive part. We needed to clarify definitions. Now we're gonna go through more penalties, especially toward the later, and the fines and the fees. Okay, those things you just have to read over and remember. So we should be able to cover it quickly and then move on to HTS tariff through the last part. All right.